Court is calling 2024 CR 09126. This is a motion. It's ex parte Shelby Rodriguez. Could I have parties announced, please?
I'm Attorney Keith Gross. I represent Anthony Rodriguez, Your Honor.
Amy Owen for Shelby Rodriguez.
James DeWiggins for the state.
All right, and Ms. Rodriguez is not present. Do you waive her appearance?
Yes, Your Honor.
All right, so we're here. There was a jury trial that was held. The defendant was found not guilty. The defense requested an expunction. The court granted the request for the expunction. And then a motion was filed. I'm sorry, what is your name, sir?
Keith Gross, Your Honor.
By Attorney Gross, requesting that a motion for a new trial on the granting of the expunction. Is that correct?
Yes, Your Honor. We did that in addition to a plea and intervention.
Right. And then there is also, let me see. And the other motion I had for you, there was a request for attorney's fees. That is not a part of this, correct?
No.
Okay. All right. Then the court will hear your argument, counsel.
Thank you, Your Honor. As the court knows that Ms. Shelby Rodriguez was found not guilty and acquitted. She filed through her attorney a request to have the records expunged. My client, he in his intervention in the new trial, he didn't get notice of the expunction trial and petition. This court granted the expunction without my knowledge, my client's, Anthony Rodriguez, his knowledge or participation. There is and has been an ongoing family custody dispute in the 73rd District Court under cause number 2023 CI 24233, in which custody of minor children are at issue before the court. During the course of the investigation and the prosecution of the criminal case, the police had gathered several records, including interviews with Shelby Rodriguez. They had taken pictures and statements from her.
Okay. And sorry to interrupt, but let's start here. Number one, you stated you didn't have notice. The first question for the court that needs to be answered is, because this is a criminal court, that's a civil court. The first question was whether or not you were entitled to notice.
In the expunction proceeding is a civil proceeding. My client has a legitimate justiciable interest in the preservation.
Based upon what? Because according to the law, and if I'm incorrect on my understanding of the law, let me know. But according to the law, the only party on a civil side that can intervene and request a notice of expunction, or that an expunction not be granted, is the state. Am I reading that incorrectly?
No, that is absolutely correct, Your Honor. And I would push back against him saying that it's a civil case. If it were not within the 30 days under the purview of this court, it would be a civil case. But that's why it was filed under the criminal case number in this case, because it's an acquittal expunction that falls under the authority of a criminal court.
All right. So first things first, does everyone agree that with regards to expunctions, if there is going to be an intervention or a request that an expunction not be granted, that's to come from the state?
That's my position.
I disagree, Your Honor, because
Well, let's pull out the code.
Your Honor, his motion is under 55A.302. And if you look at,
Just one moment.
sorry,
You say 55A
yes, 302.
.302?
Yes, sir.
All right, so here we are. Article on the Code of Criminal Procedure, Article 55A.302. Of course, there are certain reasons or legal reasons a state may ask that an acquittal not be granted. One is if there's another pending criminal case. So, Attorney Owens, is there another pending criminal case against Ms. Rodriguez?
No, Your Honor.
So that falls. And it says, in the case of a person who is the subject of an expunction order or the basis of an acquittal, the court may provide in the expunction order that the law enforcement agency and the attorney representing the state retain records and files if, one, the records and files are necessary to conduct a subsequent investigation and prosecution of a person. So there's no other pending prosecution. Or two, the state establishes that the records and files are necessary for use in A, another criminal case, that's out, or B, a civil case, including a civil suit or suit for possession or access to a child. So it says that the state has to establish this. Otherwise, what could happen is whenever there's an acquittal and somebody wants an expunction, anyone can come in and say, I don't want them to have an expunction. So according to my reading of the article, the state has to establish that the records and files are necessary for use in a civil case. State, have you established that the records and files are necessary for use in a civil case?
No, Your Honor, and we would only do that if we needed it for, say, CPS court, which we were going to go forward in a lower burden. But again, that would be something that we intended to do. We have no intention of doing so at this time.
Your Honor, the argument would be that Article 55A302 does not preclude somebody else from doing it, meaning only the state can do it. It doesn't say that Mr. Rodriguez could not come forward and say, we have a legitimate interest in seeking this. Well, the evidence, we've got most of the state's exhibits, or not the state's exhibits, but the exhibits used from the criminal prosecution. But my client clearly has a justiciable interest in maintaining and having access to those exhibits for the civil litigation.
So your argument is that anyone who's involved in any civil case can intervene or is entitled to notice of an expunction, just anybody?
No, not anybody, but in my case, it would be the spouse, where the spouse was an alleged victim of family violence, where there is an ongoing proceeding involving custody of the children. I don't think there's a dispute here that there's a civil case involving the husband and wife, involving Shelby Rodriguez and Anthony Rodriguez, that has to do with the custody of the children. And in this particular criminal case, it was alleged that she committed aggravated assault when she pointed a gun at his head. And
She was found not guilty of that.
And I understand, but in this family matter, the level of proof isn't proof beyond a reasonable doubt. It's preponderance of the evidence, and it's still.
And are you seeking to terminate her parental rights in
No,
the?
Your Honor.
Okay. Well, here's the thing. The code is the code. That's what we follow. And if the legislature wanted it to include the state and other parties, it needs to say the state and other parties may. It only says the state. Ms. Owen?
I join in the state's argument that she should be granted the expunction. I mean, it's just a backdoor way to sort of annihilate her in the divorce proceedings. And the other part of it is they requested police reports and body cams and all that stuff. So they already have everything the state's destroyed.
And I have a issue to address regarding that as well.
Yes.
Well, one of the things he's asking for relief for is for you to determine that the things they already have may be used in the custody proceedings. And for that, I'd like you to turn to 5503, where it says, when the order of expunction is final, the release, maintenance, dissemination, or use of the expunged records and files for any purpose is prohibited. Next one, it says, under subdivision 3 of this article, the person arrested may deny the occurrence of the arrest and the existence of the expunction. And when questioned, they only have to say that it's been expunged. And then an offense under this is a Class B misdemeanor. So to produce these records in any other way, once it's been expunged, would be a criminal offense.
And that's why we're here today, Your Honor. I believe there's more to that statute.
Just one moment, I'm sorry.
Yeah, I completed it too.
Thank you. All right.
Couple things.
Mhm.
I do remember reading where the dissemination of this material for money was a criminal offense. Nevertheless, the reason we're here is not because I need the state, the police agencies, or to preserve their records, because we've gathered almost 90 exhibits to be used in the civil case before.
But no. Let's backtrack a little bit. Because when cases are expunged, they're expunged. And the defense's argument that it is a misdemeanor to still disseminate records, that's correct. That is why when they do the expunction, they ask that the person be removed, all police reports, the fact that they were placed on bond with the bondsman, that's removed. Whatever the defense attorney or the person who's requesting an expunction puts in their order, then those agencies have to remove from their databases any record that this even existed, that the offense even existed. So it's not just for specific purposes that you will be held liable criminally if you were to disseminate information. Once you received it and you are aware, and usually they send it out certified to different agencies, then it's expunged, it's removed.
My client wasn't served. We're not a party to that list of people that were served with the expunction. We did find out about it. I think opposing counsel had produced it to us, but we were not on a list. In addition, that would also support my argument that my client deserved notice and a hearing, because if the state or opposing counsel is going to seek to prohibit the use of these exhibits at our family trial, then obviously I think she has a
But
legitimate.
when you file expunctions and your request for expunction, it is not involving separate parties. It's involving the person who's seeking the expunction. That's why it's ex parte, whatever it is. So when someone's seeking an expunction, and counsel, feel free to correct me if you think I'm misstating the law. But when someone seeks an expunction, it's because they've been acquitted, either by a judge or a jury. They've been found not guilty. Now, according to the code, it says the state must establish that the records in the files are necessary for use in, and it says, another criminal case. Both parties have said there's no other criminal case in existence, or a civil case, including a civil suit or suit for possession of or access to a child. But it's the state who must establish that. Separate parties or individual parties cannot.
If I can shed a little light on
Yes.
this situation, Your Honor. This comes up quite frequently. For instance, if there's a police officer accused of a crime, police officer goes to trial and then is acquitted. The records, the investigation, all the state's files are expunged and destroyed. However, when it goes to arbitration, if internal affairs spoke to him, the internal affairs investigator is allowed to remember his conversation. His client is allowed to remember the events of that night as his client sees it. You can't expunge memories. So all those people can be subpoenaed, but the state's record, the state's hard evidence, that is what cannot be disseminated and used. Does that make sense?
Yes.
And Your Honor, for example, there's videos taken from the police officers when they went into the house, interviewing Miss Rodriguez, where she made certain statements, including being suicidal, admitting to pointing the gun at this person, and that evidence has been contradicted by her, and it would be subject used for impeachment purposes. Also, some of this evidence had already been used by, I think his name is Dr. Thies, when he did a family custody evaluation and a psychological evaluation. So now, if this court's ruling, which would, I don't know if the court intends to enter a subsequent ruling saying you can't use this in the family case. I don't know.
All right, this is what the court is saying to both parties. And I want everybody to understand me, hear me clearly, internalize what I'm saying. Number one, your client as an individual does not have a legal right to intervene into an expunction in a criminal case. Your client does not have standing in a criminal proceeding to establish that he should intervene. I'm just following the law. What you all do on the civil side and whether documents can be used on the civil side, that is completely up to the attorneys over there. What I'm telling everyone, she was found not guilty by a jury. The defense requested an expunction, which legally they are allowed to do because she's found not guilty. The court signed that expunction order. That expunction order will still stand. What you all take that expunction order to mean on the civil side, that is for attorneys to discuss on the civil side with that judge. My only ruling is she's found not guilty. I accepted the verdict from the jury. The defense filed a motion to expunge. I expunged it. Counsel, I understand why you would want this information, but the court is bound by the law, and the law says you're not entitled to it. The law states that the only person who can bring up or establish that records are necessary is the state. And if people want to change what the legislature has done, then you all need to write the legislature.
The last thing, Your Honor, that begs the question is, being that the state is aware of the family proceedings and there's no dispute that civil litigation has a Rose out of custody, why hasn't the state joined in the motion? I mean, is it just arbitrary and capricious? They say, no, we know it's going on, but we don't want to ask the court. It begs the question, why would the state take that position?
All right. So this is what I can tell both parties. And please internalize what I'm saying. Number one, if the state wants to intervene in your motion right now, it's too late. Time has expired. Number two, the only persons who are allowed to establish a record stating that this expunction should not take place and who can intervene is the state. And that's what the law says. That's what the code says. If the code said something differently, if it said, individuals who are in the middle of a custody dispute are entitled to intervene, then I would have already known about that and I would have made different rulings. But that's not what the law says. So the motion or your petition for intervention, that's denied. We can go off the record. Whatever you all do on the civil side, as far as if there are some police reports out there, that's for you all to argue on the civil side and argue before that judge whether or not that should be allowed or whether that's a violation of the law. All right, is there anything else?
Thank
No,
you.
Your Honor.
All right, thank you
Thank
so
you, Your Honor.
much. Thank you.
Maybe be excused.
Yes.
Thank